Good afternoon, everybody. Let me first start by saying that it's a real pleasure to be here today. I'm very grateful to my friend Dr. Hamed for the invitation and all the SCCA team that can make this visit possible, for the invitation and the hospitality. I'm very happy in my first visit to Riyadh. Well, our panel today is about construction disputes. And I have to say that we have, for the discussion of this panel, a true expert here that unusually will convey different perspectives on the issue of contractual disputes. And I would like to start not with the disputes, but trying to avoid the disputes. You know, once someone told to me, and I think very wisely, that the parties don't want to have an arbitration. They want their dispute to be resolved, hopefully without an arbitration, as swiftly as possible. So, and in particular in construction contracts on infrastructure projects, this mechanism to try to avoid disputes or pre-arbitral mechanisms before the arbitration has become very important. So I would like to start with that and ask our distinguished panelists, Aisha, that give us her views about how this mechanism work, how they really help to avoid disputes, how effective they are, and what is your experience and how they have worked.
Thank you very much. First, it's a real pleasure and an honor to be in Riyadh and to join, be at the third SCCA. I was at the first SCCA, and it's a real pleasure to be back and see such incredible progress being made. And that doesn't go without infrastructure projects and construction and the avoidance of disputes in the first instance. But we're talking about arbitration in general, and we're talking now about construction arbitration. So why is construction arbitration a thing? Well, if we look at the caseload, the percentage of the caseload of many institutions, construction represents somewhere between 25 and 30% of the caseload. So why is that, and how can we avoid that, I think, in the first instance, is my task here. But when I think of construction and avoiding disputes, I'd like to invite you to think about construction contracts and what actually makes them different. Entering into any business transaction, we are thinking about risk. But risk and construction are inextricably intertwined in every phase of the life cycle. Construction projects are one-off type of contracts that go along over a long period of time with a multitude of stakeholders and players. And the risk allocation in construction contracts is a dynamic process. And there is usually in the construction contract a mechanism by which to handle those risks in case they eventuate, saying who's going to hold or be responsible for the results of that risk, both in cost and time, and if that risk eventuates. And there's usually in tandem some sort of machinery in this construction contract that gives a mechanism by which to access that entitlement that the parties have agreed to at the first beginning. So what we see there's going to be difficult conversations along the life cycle or along the period of life of a construction contract. So you have to have those difficult conversations, and the idea is to reach a resolution of the issue before it becomes a dispute. And how do we do that and successfully avoid, I guess I'm a little too far from the microphone, I apologize. So when we talk about avoidance of disputes, we have to think of identifying issues and see how we can have those difficult conversations before they escalate into such disputes. And because of this dynamic risk allocation, construction projects are exposed to a multitude of those issues. And over the years, what they've determined is having a process by which you identify the issues as close as possible to the moment that it arises is going to give you the best chance to resolve it and before it turns into a dispute and thereby avoid it. So if you see many construction contracts, there's a range of tools before we get to arbitration, those alternative dispute resolution tools, which include mediation, negotiation, expert witnesses, and dispute adjudication boards. So what we'll see is many construction contracts around the world, starting from the American Institute of Architects in 1888, used a multi-tiered dispute management clause to help the parties engage in those difficult conversations and adjust the contract in terms of time and money to thereby avoiding the dispute in the first instance. And many of you might be familiar with the FIDIC construction contract that deploys a multi-tiered dispute resolution clause that includes the engineer, it includes the dispute adjudication board, it includes amicable settlement, and it includes arbitration as the final last instance. And when we talk about dispute adjudication boards, they're experts appointed by the party to live with the life of the party, if they're standing dispute boards, they live with the project and are available to be consulted by the parties, either in a formal process to make a formal decision on a dispute, or better yet, if they're there appointed as a standing board in the beginning of the project, they can help the parties engage in that difficult discussion and give an informal opinion before that issue turns into a dispute and thereby avoiding this dispute. So if we think of this idea of avoiding disputes, we have to raise issues early. You have to have a mechanism or machinery to allow you to raise issues as early as possible, engage in conversations around those issues, and make those difficult decisions in terms of adjustment in time and money on construction contracts to keep the project going forward in a real-time fashion. So I'll stop there.
Thank you very much. I would like to ask you a question. You know, one of the things that we have been doing in Working Group 2, and I have, you know, our Madam Secretary here, is try to design a mechanism for adjudication, which is a model clause for international disputes. But a key issue has been enforceability. So we have been come up with a formula that will have an embedded arbitration, highly expedited arbitration within, because these at the end are contractual arrangements. So my question to you, and also thinking in all this difficult time that we have had with COVID and everything, how effective has been this mechanism? How you see these issues of enforceability when it comes to, in particular, to the DIB decisions or adjudication decisions?
Well, I think the success of dispute boards is when you don't have to get to the issue of enforceability, is when you have, and I've seen this actually work. I mean, I think, unfortunately, we're in a sea of lawyers here, and usually we're outnumbered on this panel. Many of us that have worked in construction going forward, you do see settlement and execution because that's the lifeblood of both the contractor and the employer. Because if the project is successful, the parties are successful. So in my experience with dispute boards, there are mechanisms where you can actually have a referral to a dispute board. You can have a settlement, a negotiated settlement with the parties, and issue it as a consent decision with the dispute board and the parties. And that becomes a self-enforceable tool. It deals with issues of where you can't have settlement. The other aspect of enforceability, you really need to look at the applicable law. Because if you're in a place like England, you can easily enforce it. FIDIC has dealt with that in an international context by having a multi-tiered dispute resolution clause, and if the parties don't give force to the temporarily binding dispute board decision, and it becomes final and binding. This is FIDIC 99 suite. It becomes final and binding. There's a direct route of enforcing the dispute board decision through arbitration, and then thereby gaining the power of the New York Convention in enforcement of an arbitral award.
Okay.
But enforcing a dispute board decision on its own, unless you're in the right jurisdiction, is a very difficult.
Well, we would like all of you to see what we have been doing, working group 2, and get your comments about. Ali, sticking with effectiveness, what are your view on how effective this mechanism are in your experience? Haven't seen them work in practice.
First, assalamu alaikum. I'll start with what you said, Andres, in the beginning, that parties don't want to get into dispute and they want to resolve things. And I believe, although there are some parties that they do this, they want this, but there are others that actually want a dispute. And I'll give some examples here of real life example that I know. But going back as well to Aisha's point is that mechanisms that are in the contracts are very important. Yes, dispute avoidance needs to be seeded at an early stage rather than just left to be dealt with at a time that there is a possible dispute. By looking into the contractors, by looking into the owners, by looking into the time that negotiation happens and the time that the pre-signing of the contract and the time of selecting each other, the employer selecting which contractor. Why is this? Because I have seen that there are contractors that are known to be looking for disputes, and by design, by the way that their strategy is, their profit is based on the claims that come out of the dispute. They bid for very low margin, and they wait for the dispute to happen, and this is where the profit happens. And on the other side, there are some employers that would do the work and bank on the fact that they get the performance bond, advance payment bond, pay very little to the contractors, and then terminate them and do the cycle again. So as to use that performance bond in those. So in other words, the selection of the parties are very important at the early stage, and this, if you do your due diligence in the market to see who's a good contractor, who's a bad contractor, you would be able to avoid this. So this is part of probably the avoidance that could happen at very early stage. Thank you.
And just to finalize this topic, Javier, you are the general counsel of a big construction company. Very shortly, yes or no to DABs?
Yes, I see a benefit with one caveat and 3 requirements. The caveat is that probably they don't work for any subject. For instance, for super complicated subjects or big economical, if you fix a big economical threshold, probably the standing dispute boards are not useful, because at the end of the day, you are going to replicate what later is going to come on in an arbitration procedure. But we think that for the rest of the issues that are not super technically complex or that has very high economical standards, we see the value. Requirements for that, obviously, from the contractor point of view, we need a standing dispute board that is independent, that is not always obvious. In second instance, we need swiftness, because at the end of the day, the majority of the issues are related to potential cash constraint from the contractor, so the swiftness is a must. And the last requirement for us is the awards should be interim binding, no, in order to give some enforceability to the award.
Okay, thank you. With that, I think we we can move to a next topic, which is the topic of efficiency in the arbitration. Let's move now into the arbitration stage. You know, the efficiency and cost efficiency is the big talk everywhere in all the conference arbitration. People speaks about how we can make arbitration more efficient. And case management is one of these main or preferred topics. And obviously, construction disputes is an area where you see this more frequently, the proliferation of different techniques to get the disputes solved more efficiently. So, Ali, what you can tell us in a few minutes, what you can tell us about what this, in particular in construction dispute, that these techniques that you think are the most usually seen and effective to manage the dispute more efficiently?
Sure. I think construction arbitration should be looked at as any other commercial arbitration. It could have its complexity both from technical point of view and from legal issues that may arise out of the dispute. Efficiency of cost and time. I think we need another third angle to look at: cost, time, and quality. Looking into cost, time, and quality is important to understand that whatever we do will reap benefit in terms of how efficient is the progress. There are some techniques that are used in construction disputes, arbitration disputes, in which it makes the case management better and makes it more efficient and reduces probably time and cost. And it starts with probably parties selecting their counsel, selecting the right counsel, selecting the counsel that has an understanding of the industry and have understanding of what area. Even in construction, you do have certain specialty. So selecting a counsel, parties selecting counsel could be very helpful into cutting the time and cost, because the counsel will be able to deal directly with the issues. At the forefront as well comes selecting the right arbitrators with who has or have familiarity with the industry, understanding the and having expertise in the in the area. Also having the time to give the case. It won't help having a good experienced arbitrator who's not available, for example, and things will get delayed. So these selections are very important at an early stage. Holding case management conference at very early stage of the dispute is very helpful. Trying to not just have the very first case management conference once and for all, but no, having built-in case management conferences during the period of the dispute, factoring it in the timetable to try to reduce any differences that may be there, that may arise, and deal with issues that may arise as and when they arise. Before having the case management conference, it's important as well for, it's advisable for the arbitrators to share with the parties and parties' counsel an agenda of what the discussions would be during the conference. This would help each party to come prepared and assure that the time and effort that have been that will be taken is going to be in the right direction and it will be efficient. Preparing terms of reference is another thing that is important for the arbitrators to do. Now, we understand that not every institute requires that terms of reference is required. However, as the president of the ICC court said in one of the articles, Claudia Salmon, said that we do have requirement for terms of reference this is not an outdated practice. This practice allows the arbitrators to get a grip of the case at very early stage, and will be able to look into the issues at that stage. So we are keeping the terms of reference as part of the ICC. This is what Claudia was saying. And I believe this is an important thing for the arbitrators to do at very early stage. Out of the terms of reference, there would be issues that will arise, and I think communication with with the parties, trying to get from them summary of the issues that constitute the dispute of the parties, will cut short a lot of issues that may be floating around, but not directly to the point. So trying to minimize and narrow all the issues by asking parties to make summaries, provide them to the parties, have them part of the be part of the terms of reference. The understanding of the case as well could help in deciding initial issues that may arise, whether there is need for bifurcation or not, whether there is a decision that has to be taken in terms of jurisdictional challenges that may arise or be raised by one of the parties at that early stage, would make the arbitral tribunal able to deal with the case on timely manner and in an efficient manner, and certainly reduce the cost that will be there. Deciding timetable is very important, with a precise time for the parties to make submissions. And I'll stop here.
Thank you very much, Ali. I have a follow-up question for Aisha, based on your experience, Aisha. If you will have to mention one thing that Ali hasn't mentioned, and in your opinion is very important, that at the stage of a case management conference, or as a technique to make the proceeding more efficient, arbitrators should take into account, what that one thing would be, in your view?
Well, I'm going to borrow a note from your page as you opened it today, and said that parties want to resolve their disputes. They don't necessarily want arbitrators to decide their disputes. And I think early on, the one thing that, just in adding to everything that Ali had said, is for the arbitrators for counsel and for the parties to bring this project to life within its life cycle to the arbitrators, such that you can design if settlement is a possibility or not. So I think some people in the audience might know that I'm a fan of actually having a site visit if there is a site to be visited. So early on, as part of setting up the terms of reference or the like, and also understand if settlement is possible within the life cycle of the project. Because if the project is very near commissioning, there may be an opportunity for settlement. But if the project is 10 years old and it's already been re-procured, it's just a matter of beating a dead horse and doing a forensic analysis. So I think you need to know what the contours of the construction project are, to help build a process that is tailored for the party's project.
Speaking about, case management, where issues of evidence are also discussed, I would like to turn to you, Franco. You are, as said, we have many perspectives in this panel. Franco is an expert, well, among other things, but he's an expert, and works as an expert consultant company. So I would like to ask you how you see the role of, the role of expert in construction dispute. It's impossible to conceive a construction dispute without experts. We all know that. But there's a lot to say about this fundamental and necessary part of construction dispute. What are your, in your long experience, your insights about how this participation can be improved and make it more efficient and useful for the tribunal and the resolution of the dispute?
Thank you. Well, first of all, a plea for early engagement with the expert. And the engagement really needs to start, first of all, between the expert and the party appointing the expert. They need to understand perhaps whether there is even a technical case to answer. And if so, how best to articulate that case from a technical point of view. There are a number of cases that I've been involved in where the pleas are already in, the expert is appointed later on, and then they have to work within this framework, which is not something that they can move away from. So there's a first hurdle, if you like. So far as the early engagement between the tribunal and the parties is concerned, I think the tribunal needs to give some framework to the parties. It, I hope, will include what I see increasingly as the convergence of thinking in various jurisdictions about the role of the expert and the need for the expert not to be partisan and to be objective in the work they do. There is, on a number of occasions, also an issue which arises to do with whether or not experts should be coached by the party's representatives. We don't have an international standard for that, and I think it is part of an important issue about ensuring the parties, when they appoint their experts, are actually proceeding on the basis of a level playing field. I think the other important area may well be the importance of the declaration from the expert when they come to conclude their report. What will that declaration include? There are some standards. Some of them are professional standards. Some of them are institutional standards. But the sometimes challenging thing for an expert is to be honest about the declaration he or she makes, particularly in circumstances where perhaps they have an instruction which limits what they are asked to comment on. So making some of the declarations that they need to make, i.e., I've considered all the relevant evidence, really quite challenging. So coming back then to the tribunal itself, the paramount need of the tribunal is to understand from the expert what its objective view is about a particular topic. And the ability to relay that in a clear and concise way so that the tribunal can understand it, pick it up, and be able to replicate it if it agrees with it is quite important. What about engagement with the experts between the tribunal? I think that, again, needs to be very early. They perhaps need to be comfortable that the tribunal is not going to treat them as somebody who is simply going to be given a hard time in the witness box, perhaps to explain to them what they see their role as the expert, what is expected of them, and how it is that they're going to engage in that dispute resolution process, how the evidence will be given, in what format. And then finally, the question of the expert engaging with his or her opposite number, i.e. between the experts. Again, that really ought to be as early as possible, hopefully before any final view is formed by the expert as to his opinion and committed to writing. That's why, to a degree, I have some difficulty with the memorial style of pleading, which very often requires an expert's report or an expert's view to be annexed. Very often, as I find, the experts are very circumspect at that stage, and what you have is a much more fully considered expert's report in due course, seen for the first time by the parties, and therefore not aiding the process. So that's what I would say about an early engagement of the expert. Moving on to the process itself, there has to be, I think, a continual engagement with the experts. I think a good tribunal will make sure that the experts are doing what they're doing properly and within the timescales. And if there are issues which arise, they want to know about it and be able to direct the experts. Very often, there will be conference calls or meetings with the tribunal that's alert to the need for that. And I think it's also important for the tribunal not necessarily to encourage the experts to be in touch with them, but not to close off the ability of the expert to speak directly to the tribunal. May be a good reason for that. For example, it may be that the expert feels that the opposing side's view of what it is saying or doing is misrepresented, and it wants the tribunal to hear about that. So then moving on to the testimony of the expert, I think increasingly what I'm seeing in the international marketplace is a diversity of forms of securing the expert evidence. And it's usually a mixture these days, I have to say. And I'd like to go through them in order chronologically. I think that the evidence should be taken. The first is witness conferencing, where you have the two experts giving their view at the same time about particular topics. And I do think that it's sometimes useful to get the experts to question each other in important areas so that the tribunal sees what each of them is saying. Of course not, one hopes, in a partisan way, but simply to explore with the other expert the limits of the opinion. Secondly, there's the question of cross-examination. That's traditional in the civil law system. All too often, in my experience, that can degenerate into an attack on the expert, him or herself, not having very much to say with the merits of the expert's opinion, but simply attacking the credibility of the expert. And I think that is not only counterproductive, I'm not sure that it helps the tribunal very much. And far more effective, in my view, is if you have a difficult case as prosecuting counsel, or as a cross-examination counsel, I should say, it's far better to draw out of the opposing expert those positive aspects of his or her evidence rather than trying to attack the expert, him or herself. And finally, the tribunal's questioning in an inquisitorial style, I think, is also very helpful, because at that stage the tribunal will have heard from the experts themselves, will have heard the cross-examination, will have some questions which it hasn't had answers and which are of interest to it, the tribunal. Typically, that ought to be done by a tribunal that is knowledgeable, that is on top of the material. It's of no use, frankly, for tribunals to ask questions of an expert simply for the sake of asking the question and being seen to be active. Far more important, what does the tribunal yet need to have answered, and put those questions in a probing way to the particular experts. And then finally, one of the features that I'm increasingly seeing is whether or not there ought to be engagement with the experts and the tribunal post-hearing. So you have the ability, as it were, to have the tribunal meeting with the experts without the parties present. This typically happens on areas of quantum, where the tribunal needs the assistance of the quantum experts to better understand what the consequences of a decision might be financially. And that obviously is much more likely with a tribunal that does not have quantum expertise. It can be done perhaps ahead of time by the experts, the quantum experts, producing a schedule, which can be quite challenging because it can be very large and time-consuming, but which allows the tribunal to pick A or B in relation to particular issues, and then the financial consequence is worked out for the tribunal. And I've seen that being used successfully, but on very large disputes. Well, obviously, there are issues which are then raised, which is, well, what about the issue of natural justice? The parties may have strong feelings about whether the experts should meet privately with the tribunal. After all, they may be raising questions with the experts which have not been put by the parties, nor are the parties given the opportunity to deal with that. Now, a well-formulated direction to the parties will actually allow the tribunal to raise those questions directly with the parties in areas where they feel they are receiving or having to deal with evidence that's not been put to the experts in the hearing.
Yeah. So, Franco, you know, the problem with this topic is we can spend the entire day, not the entire day, an entire event in construction disputes. But I would like to, if you allow me, to move to a different topic. And the topic is, we are discussing about disputes. Let's discuss about what happened even before the dispute, which is contracts and risk distribution and applicable law. And we have here, again, we have the general counsel of a big construction company that works all over the world. And I would like to understand from your point of view, Javier, how do you see the importance of, or the typical contractual clauses that help you distribute the risk from your perspective, as well as how is the role of applicable law in all these disputes?
Sure. Thank you. So let me start with some facts. The first one, in the last 20 years, we have lost like half of the contractors that were able to deploy mega projects. That's a reality, and now we have a constraint in the number of big companies that are able to develop a big project. In second instance, the projects day by day are being more complex with interaction with famous architects, you know, technicalities that are amazing for the lawyers, etc. In third instance, it's a reality as well that the arbitration and the litigation procedures are exponentially increasing. And in last instance, what is happening is that there is a bunch of projects worldwide that are stuck, suspended, or otherwise for very big infrastructures, we are finding, or the clients are finding, that there are not bidders to the different, bid procedures that the clients are developing. For me, what is the reason for that is the risk allocation. The risk allocation that in the last 10 years, I think that has been against the contractor, putting all the pressure in contractors, and obviously I'm talking about my book, but it's a reality. And how to solve it? I don't think the solution is to act the other way around and to put more pressure in the client. But there is a bunch of risks that cannot be covered exclusively by the contractor. And for me, the only solution is to move to other kind of contracts, apart from the traditional D&Cs or EPCs, and going to collaborative contracts. No? Collaborative contracts in which both, in which the designers, the client, and the own contractor share the benefits and the risks of a potential projects. The major risks, I mean, I'm not talking about small risks like geotechnical, traffic management, etc., that can be easily allocated. I'm referring to the unknown, no? These risks that are not, that no party has a leverage to control them. Unfortunately, we have lived the COVID, we are living now the Ukrainian war, the Palestinian problem, etc., etc. So these kind of events cannot be controlled by any party. And for me, the only solution in mega projects that might take, or that can have lead times of 7 years, is to establish another level of collaboration between all the stakeholders. No? And we have clear, this is not a utopia. I mean, in first instance, both NEC and FIDIC are expanding their contract suite, incorporating collaborative contracts in their portfolio, and on top of that, perhaps the second largest country in infrastructure after Saudi Arabia, that is Australia, is, I mean, I will say that 40%, something between 40% of the, or 50% of the contracts or the main regions, Victoria and South Wales, are using this collaborative contract, so it's not a chimera. If that's not possible, and coming back to the original point, what we should do is try to apply fairness and to use at least 4 or 5 figures that I think are mandatory to be included in the contracts. No? The first one is the use of the good faith principle. I know that this room is plenty of England and Wales lawyers, and probably they are going to disagree with me because part of their job is to discuss about good and bad faith issues, but I think all the contracts should include good faith obligations. On the other side, I think that the civil law countries, we can use the benefit of a couple of figures, legal figures from the common law system, like the supervening events. We only use in the civil war pure force majeure events that are super restricted, and I think that we have a lot of things to learn from the common law war on that respect, the supervening event. And finally, because there are another a bunch of them that we can dedicate a lot of time, but can be to incorporate in the civil law procedures things like discovery, that we don't have that figure in the procedural way, and I think that the simply threat of being obliged to show certain information might help to avoid disputes in an early stage.
Thank you very much, Javier. Just a very concrete question, if I may ask, based on your experience around the world, how much the legal culture of each country influences all the things that you have mentioned in general?
Obviously, I mean, these collaborative contracts are more easy to implement in the common law countries because mainly because the awards of the contracts, of the big contracts, are more are done on a confident basis, so it's more easy to implement collaborative contracts in these jurisdictions. I think in civil law countries or in the Gulf countries, perhaps it's more difficult, but I think it deserves the effort.
I think I have time for 2 minutes, and I would like to come back to you, Aisha, and I would like to, in these 2 minutes, to use your experience in FIDIC and with standardized form of contract. How effective do you think are the standardized form of contract in somehow bridge the gap between this applicable law and legal cultures and coming up with somehow of a common law of construction contracts?
Yeah, thank you. And I think it's important to understand that FIDIC contracts, it's important to take FIDIC contracts as a tool, as a starting point. You cannot, there is no global standard contract. And so FIDIC contracts are written in 2 parts, the general conditions and those conditions of particular application. And you must do your due diligence to understand what the applicable law in your jurisdiction that you're going to be operating is. For example, decennial liability is a thing in many civil law countries. It is not a thing in FIDIC. So if you want your contractor to take out decennial liability insurance, or your designer to do so, you need to put that in your particular conditions. So I say that standard contracts are a tool, but they don't erase the responsibility of the employer in the upfront planning and the upfront understanding of how those provisions of that contract are understood in the context of the law under which you're operating. And the wrong time to be surprised by how that particular law interprets a particular provision in FIDIC is an arbitration. It is much better to do it forward-looking, do your due diligence, engage with your local council, understand what particular provisions you need to put in there. And because there are gaps, I think, from the mandatory, there's many mandatory laws that you have to take into account. So it's a tool.
I always like, thank you very much, I always like when we are in events like this to give 30 seconds to 1 minute to the panelists to give one takeaway to our audience based on their plenty experience in construction, especially since our panel is about challenges. So why don't we go now in reverse order, and you have from 30 seconds to 1 minute, give one takeaway to our audience about this construction dispute. Javier, let's start with you.
Sure. I mean, coming back to my original speech, I think taking advantage of this forum, I think Saudi Arabia has a super opportunity to start implementing, to be pioneer, and to start implementing this collaborative contract system that I think is in the benefit of all the stakeholders. So I think it's a good way to improve the performance of the projects.
Change the paradigm to collaborative contracts. Good.
Sure.
Franco.
Engage early with the experts, and on collaboration, once you're down that road, you need to continue to collaborate.
Thank you. So experts during the entire time of
Yes.
the event. Good. That's good for business as well, right? Excellent. Ali.
I would say start very early before signing the contract. Do your due diligence, see which culture you are in, which legal system you are in. To your point, engage counsel, put in whatever clauses that are there, and I will have the rest of the 1 minute to say thank you to the SCCA, Dr. Hamid, and the team for this, and invitation for speaking.
Thank you, Ali. Last but not least, Aisha, please.
Planning, planning, planning. Because if you're doing anything complex, and any infrastructure project is complex, you need to think slowly, you need to be meticulous about your planning, and you can execute quickly. But if you fail to plan, you're planning to fail.
Preparation, preparation, preparation. Well, thank you very much. Thank you, Dr. Hamed and the SEC, for an excellent panel to our panelists.